the Oil Conservation Division. We have a special docket today of NOV cases filed on behalf of the Oil Conservation Division by Mr. Michael Hall. We're going to go through these in the order that I see them on the final docket worksheet prepared yesterday and sent out to all the parties. I'm going to start with case number 25921. This is the Oil Conservation Division versus Bill L. Miller.
Good morning, Mr. Hearing Officer Michael Hall on behalf of OCD. We're ready, but I would like to announce that we have agreed to an SFO that Mr. Bain on behalf of Bill L. Miller has signed. And so we are kind of did that yesterday. So we don't have the director's review and signature on that, but I on behalf of OCD have agreed to the terms, and Mr. Bain has also, namely, there was an issue with Bill Miller had plugged a well many years ago. The paperwork had been filed with BLM. Mr. Bain was finally able to get some of that old paperwork, and I've seen evidence of this. He's in the process of trying to get that submitted to OCD properly, and so I'm satisfied. He's agreed to have until April 30th to get that done properly. He's in the process of that. I'm optimistic he'll get that done earlier, as well as a $100 civil penalty.
What's an SFO?
That's a stipulated final order. In NOV cases, that's instead of an agreed compliance order in the case where we haven't filed an NOV, a stipulated final order is an agreement between the parties.
What was was Mr. Bain made aware of today's hearing?
He was. In fact, he's emailing me this morning. I anticipated he would be here, but he might be relying on the fact that he signed off on the SFO as we had discussed. So if he's not, that's why he. Prior to that, he said he would be here, and he's been in not overwhelming constant contact, but he's been in constant contact with me, kind of keeping me up to date with some of his difficulties with filing and finding some of that paperwork. So he's been very responsive.
So in the NOV, let's just get it on the record. What was Bill L. Miller? What's Mr. Bain's relationship with Bill L. Miller?
Well, my understanding is Mr. Miller himself passed away some years ago. Mr. Bain, I believe, had been a pumper operator or something oil field work related. I can't remember the exact relationship, but he knew Mr. Miller through that. I think he purchased or inherited. Somehow he came into possession of the operatorship of Bill L. Miller. Only one well was involved. It was this one. He understood it to be plugged, which in fact it was, but making OCD properly aware of that has been the issue.
So has Mr. Bain updated our database with his name and contact information?
I don't think so. I think he has another operatorship. I believe it's called R&M. He's trying to submit through that. So whether that's acceptable to the powers that be, I don't know. He might need to get re-registered. I believe he's also been in contact with Mr. McClure and also maybe even Mr. Jackson. I'm satisfied that he's trying to do the right thing, and maybe computer work isn't his forte, but
so what are the terms of the SFO?
The terms of the SFO are that by April 30th, he will have that paperwork properly submitted to OCD, and that he will pay, it's by the same time, $100 civil penalty.
Okay. And then the case will be closed.
Case will be dismissed once Director Chang has signed off on that.
Okay, and you're submitting the SFO directly to Director Chang?
I do, and then I will submit it with a motion to dismiss to you through Freya.
So will Mata E be the go between you and Director Chang?
Normally I think I submit those directly to Director Chang, but I'm happy to do it however you would like me to.
Okay. with the other NOVs that we submitted to the director a month or so ago, we submitted them through MATA E. That way she could make sure that there are order numbers on there. She puts the order numbers on. She makes sure that there's places for him to sign and date. And then she also uploads the document to the file and makes sure to serve it on the respondent.
So the way I'm accustomed to that is, as opposed to an order on an SFO, I would send that to Director Chang, but the motion to dismiss would be sent through MATA E. And I believe that's what's ultimately uploaded into the case system with the SFO attached to the motion to dismiss. So, but again, you're the boss here. However you'd like me to do it, I will do it that way.
Well, just for consistency's sake, I think let's have everything go through MATA E. That way, I mean, because the way you're proposing it, you would send it directly to the director, but he would not send it directly back to you. He would send it to MATA E for filing.
He would send it to me. I would submit a motion to dismiss upon all the proper parties having signed off on the SFO.
That's fine. If that's how you want to do it, if you want to wait to submit the motion to dismiss until you get the signed SFO, I understand that that would be a check on your list that maybe you'd rather do it that way. So are you going to add the order number to the document?
I'll add the case number. In that sense, it's not, I guess it is an order, but it's a little different than the orders we've been doing this year so far, other than one case.
So you're saying it won't have an order then?
It will have a case number and it will have the attached stipulated final order, but I guess it's not something that you at least in OCD's custom and practice, I don't think the hearing officer is generally signed off on the SFO.
I just meant if it has an order number, then someone could look up that order in the database with the order number.
Absolutely.
And ultimately, it is a type of order. It's a final order, as you said.
And maybe that's something I should get clear with leadership, whether we want a motion to dismiss with that attached as well as the SFO as a separate document.
Okay.
That will be easy to do.
Okay.
However, the powers that be want that listed in OCD's imaging system.
And if you want, MATA E can provide the order number to you if you want to control the document and just keep it between you and the director. That's fine.
Don't you usually assign it an order once?
It's a system generated number.
Okay.
When I put the SFO in our data, generate that number.
Okay.
Sorry, I was getting a little confused about case number and order number. That's right. Rob's done.
Yes.
Yeah, Rob's done that with a couple of
didn't know
SFOs
that.
we've done.
I didn't know that you had the capability of assigning an order number. That's great. Excellent. All right. Then it sounds like, from what I understand, I'm just going to repeat this back so
Sure.
we all understand what's going on. You're going to once Mr. Bain does what he's supposed to, whatever that may be between you and Mr. Bain, you're going to provide the director with an SFO with an order number on it. Once you get that back, you will provide a copy of that to MATA E along with the motion to dismiss the case. That would be with prejudice or without prejudice?
I don't know that it says either. I guess on the spot here, I would say without, in the event that they're non-compliant with the SFO, we would have the ability to then. But actually, the SFOs generally say we have the right, if they don't comply with any deadline, we have the right to go plug, take away their right to transport. So it may be 6 of one, half a dozen of another. But if I'm on the spot, I'm going to say without prejudice.
Okay. So you'll provide that to MATA E.
Yes, sir.
And then she will close the case in the system and she will upload the documents and serve, I guess serve Mr. Bain. Now, you don't need her to serve it certified mail in this case, right?
Not in this case. Mr. Bain, in fact, has already signed the SFO, and we're confident he's receiving emails. We've been in contact with him that way. So in this particular case, I don't think that would be necessary.
Perfect. All right. Is there anything else on this case?
No, sir.
All right. And MATA E, you don't see Mr. Bain online, do you?
I believe last hearing, he was maybe by a phone number. So I don't know that it said Roy Bain. My recollection may be off on that, but,
Okay.
um,
But he appeared at the last hearing in March.
he did.
Okay.
Uh,
All right, then if there's nothing else, we're off the record in 25921.
Okay.
All right, let's go to number 2 on our docket, 25922. This is the Oil Conservation Division versus Benton Crude Oil.
This is another case that's been settled. Benton's representatives have signed off on an SFO, which is awaiting the director's review and signature. They have a lot of inactive wells. The terms of the SFO is they purchased the operatorship, they purchased the company, is my understanding. So they are now producing all these wells. And so it's just been a question of getting some of the paperwork from prior to their ownership, submitting, and they have sent me all that. I don't know that it's now in the system, but they also have a deadline coming up of that.
What is it?
I believe it's May 1st. I'll have to pull it up. It might be April 30th. And so
Who have you been dealing with?
I've been dealing primarily, I've also been emailing Benton Crude 25, which is Ty Guffey, who I think is the new owner, but primarily dealing with a landman or land person in Texas named Rachel Reasoner, I believe is her last, how you pronounce her
Are
last
either
name.
one of those, are either Rachel or Ty on the call with us today?
I don't know. Let me pull it up. Sorry, I don't have the hearing pulled up. I should do that.
I see Mata, he's trying to find them. I don't think she's having much luck with.
But they have signed, Mr. Guffey has represented, he has the power to bind the operator, and he has signed off on the terms. The other part of that is a civil penalty, based on some dealings and some delays on their part. I believe the NOV says 16,200 or thereabouts on the civil penalty. We agreed that they would pay 15,000. 3,000 a month for the next 5 months.
And that's in the SFO?
Yes, sir.
Okay. All right. All right. And they knew about today's hearing?
Yes, at least Rachel, who I've been talking to, but again, I can't speak for why they are or are not here, other than they have signed off
Okay.
on the paperwork I proposed to them and submitted to them. In fact,
In the
negotiated.
future, if you do have an SFO
Mhm.
and they get it signed, please let them know that I'd still like to hear from them. I just want to hear from the respondent what they understand the SFO means to them, that they are going to comply with it, et cetera. So if you could let them know that in the future.
I certainly will.
All right. All right. Is there anything else on this case?
No.
All right, very good. Let's move on to case number 3 on the docket, 25926, Burns Express.
Okay, OCD is present and ready.
All right, and who have you been communicating with at Burns Express?
It's been some time, but I communicated in, for instance, regarding the previous continuance with a man named Kenyon Burns.
Okay,
Um,
and we served him with the NOV and the docketing notice and all of that?
yes, and in fact, I know he's aware of it because he's called me.
Okay.
So,
And he knows about today's hearing?
I haven't, he should, I can't speak to that.
And what is his name?
Kenyon Burns.
Kenyon Burns, okay. Mr. Kenyon Burns, are you with us? All right, I don't believe he's with us, but go right ahead, Mr. Hall.
Yes, OCD would offer exhibits 1, 2, 3, and 4 attached to his pre-hearing statement.
Tell me a little bit, thank you. There's obviously no one here to object to that, so I'll admit those without exception into evidence. What's the general allegations here and what's the fine?
General allegations are regarding, and then I believe it's, let me look at the number. I'm just gonna get to the NOV here. Sorry, my computer's going slow. Let me try it a different way. Okay, sorry, Mr. Hearing Officer, I guess when I plugged in my internet, it's My global share isn't working well. I apologize. Let me see if I can reconnect. I had it pulled up, but now it's not showing. Um, Okay, let me. I'm sorry. This thing.
Protect.
I think so. I think that's what I have to. Sorry, Mr. Hearing Officer, I'm having some technical difficulties here. I've had to call IT about this problem before, and I'm worried I may have to do that again.
Do you have, you may not have, a secure internet access, but do you have any internet access?
I don't think so. Let me see here.
Are you connected?
Yeah, it says connected and secured on the M there, but then there's this global connect, which when I come down
Yeah.
here, I have to use, and it's
You
not,
do have to use it, yeah.
it's not working.
All
And
right.
that's happened to me before.
Let me see if I can pull it up. That way I
Okay.
can put it on the
It would
record.
either the NOV or the pre-hearing statement would be helpful for me to answer your
I
question.
understand.
I apologize. I'm
Sure, sure.
unable to pull it up.
Give me just a minute. Oh, and I have the same server error.
Oh, you do?
The runtime error, I'm getting it as well. Do you want to, IT is right here. Why don't we take a 5-minute break? Why don't you take your computer right over here
Great.
and let's get them, because I'm having the same error and I need to put some stuff on the record.
Perfect.
So we're
Perfect.
going to take a
Thank you.
5-minute break. Thank you. We're off the record. All right, it is 2 minutes before 9 a.m. We're back on the record. It is Wednesday, April 15. Counsel for the New Mexico Oil Conservation Division had to move upstairs to gain internet access. We were discussing case 25926. This is Oil Conservation Division versus Burns Express. Mr. Hall? Is he muted? Would you unmute yourself?
Yes, can you hear me now?
Now we can, yes.
Okay. My computer is still messing up, but my phone, I am able to use that. Let me see here. I'm trying to pull up Burns. I'm still having some of the same issues, but I'm gonna try again. Okay, I think I'm gonna be able to do that part anyway.
Okay.
Okay, yes. Are you ready for me to proceed, Mr. Hearing Officer?
Yeah, do you remember the question that I asked, or should I ask it again?
No, I do, I recall it. The
Okay, go
general
right ahead.
is, this operator has one well. That one well, has been continuously inactive since at least September of 2021. We're seeking our typical inactive well, remedies, namely a civil penalty of $450 in this case. The ability to, cancel or terminate, permits or authorization, the ability to plug and abandon the well, as well as remediate and restore the location, um, uh, forfeiture of financial assurance, shutting in well, and termination of ability to transport.
Okay, and who have you been communicating with at Burns Express?
A man named Kenyon Burns. Sometime
Okay.
before the last continuance, I have not heard from them since that time.
Okay, and Mata E, I thought I saw a picture of someone that looked like a respondent. Do we know who that gentleman is?
If you're asking me, Mr. Burns is I believe, the only person I've communicated with the relationship to this
Okay.
op.
Very good. I understand, Mr. Hall. I'm wondering who this gentleman is with the hat on, with his camera on. Sir, are you here for a case?
That is Mr. Bain, who agreed to the
Ah,
SFO,
yes.
Bill Miller.
Okay, very good. So, Mr. Bain, just stay with us for a minute. I'm going to come back to your case in just a moment. So, all right. So, Mr. Hall, let's see. You've entered the evidence into the record. I've accepted it. You've told me a little bit about the case. How do you want to proceed on the case?
We would seek an order to the effect of the relief sought in the NOV.
Okay, as a default order?
Correct.
All right, sounds good. So, are you going to draft that?
Yeah, yes, I'm happy to.
All right, sounds good. Very good. Okay, and 2 weeks, does that sound reasonable?
Yes.
Okay. All right, then I don't think we have anything else to do on this case. So we're off the record in 25926. Let's go back to 25921. Mr. Bain, would you enter your appearance, please? Is he muted?
Go. There we go. There we go. I'm sorry, I was hitting the wrong button. Sir,
No
I
problem. I hear
apologize.
you. I hear you. Would you enter your appearance, please?
Roy Bain on behalf of Bill Miller.
Okay, perfect. I recognize you from a month ago.
Yes, sir.
It's my understanding, I don't know if you heard when I called your case about 15 minutes ago, but we were advised by Mr. Hall that you've entered into an agreement with the division to deal with your case, and that you have signed a stipulated final order. Is all that correct?
Yes, sir.
Okay, very good. And you entered into that agreement voluntarily?
Yes, sir. Yes, sir.
Okay, all right. Okay, very good. And did you know that you have a deadline of April 30th to produce some information for Mr. Hall?
Yes, sir. We talked about that yesterday, and got a couple more reports to redo, but I should have it all done within that time frame with no problems.
Okay, very good. And Mr. Bain, I'll venture a guess here that if you need more time, that what you should do is to discuss it with Mr. Hall. Instead of just missing a deadline, just discuss it beforehand.
Oh, yes, sir. Yes, sir. Always. We become quite friendly on the phone.
Oh, that's great. Well, I'm glad to hear it. Thank you for participating today, and good luck with your endeavors.
Thank you, sir.
Bye,
All
Mr.
right.
Bain.
We're off the record in that case, Mr. Hall. Let's move on to 25939, number 4 on our docket. This is the division versus craft operating.
Division is present and ready.
Okay. And do we have anyone, who have you been meeting with? Oh, I see someone there.
I believe, I haven't seen her or I don't believe spoken on the phone, but I have, received an email or two from, Miss Candace Kraft, who I believe is present.
Ms. Kraft?
Yeah, I'm present. I don't know if my mic is on.
I'm sorry, what did you say?
I am present.
Or I think you might have two microphones at the same time going
Oh, well, okay.
because of the echo. Why don't you try muting one of them, either your phone or your computer, and just talk with one microphone?
Okay. How did that work?
Good. Would you like to enter your appearance in this case?
Yes, this is Candace Kraft.
And what is your relationship to craft operating?
I am the owner and president of Kraft Operating.
Okay. And you received the notice of violation and the docketing notice in the mail?
I did.
Okay, good. Do you understand the charges against craft operating?
Yes.
You do. Okay. Do you intend to present evidence on your behalf?
I can represent myself today. My attorney is still in Japan. It's about a 16-hour difference. And I am the agent, was the agent for M&M Energy in the operation of this well.
I'm not sure, how does M&M Energy relate to craft operating?
M&M Energy owns the lease for the well and the majority working interest of the well.
But what is your relationship to M&M?
I'm their agent.
Oh, you're their agent. Okay.
Yes.
Do you mean that you're registered at the Secretary of State as their agent?
No, I mean, under the rules of the lease agreement and well operating agreement, I'm the agent for M&M Energy.
Okay. I'm going to go to Mr. Hall now. Mr. Hall, I'm not sure what M&M has to do with craft operating besides what Ms. Kraft just told me. I understand what she told me. Did you understand that as well?
I understood what she said. I can probably clarify that some on voir dire or cross-examination. But I would represent to you, Mr. Hearing Officer, that the leaseholder of this well is not a concern to OCD. The registered operator is, that being Kraft.
Okay, that makes sense. I understand. Have you sent Miss Kraft the exhibits that you intend to present?
Yes, they were emailed to her.
Okay, Ms. Kraft, how many exhibits are there, Mr. Hall?
There are 4, but actually we would only offer 1, 2, and 3, given her appearance and acknowledgement of notice.
Okay, Miss Kraft, have you received the exhibits marked by the division that we will be talking about today?
Yes, and I sent a response to, and I spoke to Mr. Hall as well about the state land office. They're saying the lease is no longer M&M Energy's. And I sent a letter to Hall about that, Mr. Hall.
Okay, Mr. Hall, did you receive that?
I don't know if it's the same document. Yes, I'm aware that the state land office terminated their lease, and there was some back and forth. Mr. Biernoff, general counsel for the state land office, also sent me some communications. I would just for purposes of this hearing, our concern is well inactivity, and I think it's undisputed I think Ms. Kraft will agree that the well has not been operated or produced or plugged for a period of greater than 15 months.
Okay. What are the allegations in the NOV? Because I can't see it. We don't have the imaging system available.
I will be happy to tell you. It's another case with one well operatorship, that well being inactive and has been since at least April of 2024. And we seek the same remedies we do in every case. But
Okay.
the allegation is the well has been inactive since at least that time. And I think Ms. Kraft would acknowledge or states that that's because she lost the leasehold with state land office. It's on state.
Okay. All right. Ms. Kraft, before I ask you any questions, I want to make sure you understand your rights here at the hearing. This is an administrative hearing. The rules of evidence don't apply here. I'm here to provide the director with a full and complete transcript and any evidence that you have, as well as the division, so that he can make a decision on whether or not the allegation is true or not. We operate by a preponderance of evidence, and you have the right to challenge any evidence that the division seeks to admit at this hearing. Do you understand that?
Yes,
All right. So the allegation here is that there's a single well that has been inactive for approximately 2 years, if I got the dates right. Is that right? Yeah, okay. So Ms. Kraft, what do you have to say about that?
I'm saying that Mr. Burnoff was incorrect when he said the well was inactive, and he told me to cease and desist in producing it. And at that point, I ceased and desist. So since then, it has been inactive, and I was not allowed to go on location.
Okay, I understand. Is there Mr. Hall, is there a filing requirement when a well goes inactive?
Oh, the C-115 reports are required even if no production occurs, which I don't believe has happened. And so under OCD rules and regulations, when a well hasn't been, no production has been reported for a period of 15 months, that well is included on the inactive well list. And in fact, that's Kraft's only well in OCD's records. Mr. Hearing Officer, may I ask a question of Ms. Kraft?
Yes, please go right ahead.
Ms. Kraft, what steps have you taken to contest the state land office determination that your lease had terminated?
Well, it was M&M Energy's lease, not mine, and I've been trying to get in touch with M&M Energy. It's my understanding that Mr. McGee is in court-ordered rehab for a few more months, and I'm not able to get in touch with him. He's the majority interest owner of the well, and he is the owner, was the owner of the lease that he required years ago for $250,000.
So you have not, you as agent for M&M, or you would agree that Kraft Operating is the operator of this well, correct?
Correct.
Okay, so has Kraft Operating filed any litigation in district court to contest the state land office's determination that this lease had expired?
No, that should be M&M Energy's responsibility.
Has M&M done so?
Not that I'm aware of.
So is it your position that OCD should just never enforce its rules against craft operating? Don't you think you have some affirmative obligations to contest the determinations of state land office? If you disagree
I
with
would
them?
love for the OCD to help me with Mr. Burnoff and get me to be able to get back on the well, do an acid frac that I wanted to. I would love for their help on that.
Did you understand my question, ma'am?
Did you understand my response? I would love for you to help.
So you think you want us to help you acid frack the well? That's your defense?
No, I'd like you to help me with Mr. Burnoff at the state land office to help me get the lease back to M&M Energy. So as agent, Kraft can get on the well and acid frack it in the Yates formation.
So do you think it's our job to help you with state land office or to enforce the Oil Conservation Division's rules?
I don't know the answer to that.
Well, isn't it your job to deal with that, not OCD's?
Well, I've tried to deal with it and I've sent information to Mr. Burnoff and he is not amenable to discussing it with me.
And to be clear, you have not filed any kind of litigation to contest that, correct?
As it's not and never was my lease, it's not my lawsuit.
You are the operator of this well, correct?
I am the agent and operator for M&M Energy.
And you are the listed contact for Kraft operating NM LLC, correct?
Yeah, correct.
Do you agree that this well has not produced in 2 years?
It last produced in April of 2024.
Are you aware that you are required to produce C-115 reports regardless of whether a well is producing or not?
I thought if it wasn't producing, you didn't have to do those reports.
Are you aware that a well is considered inactive if it hasn't produced in more than 15 months?
Yes,
And do you contest that determination by OCD?
no,
I'll pass the witness.
Okay. So have you offered your exhibits into evidence?
I did. I don't know if you've accepted them. We again offer exhibits 1, 2, and 3 attached to OCD's pre-hearing statement.
Okay. Ms. Kraft, have you seen exhibits 1, 2, and 3?
I think so, Your Honor, yes.
Okay. Do you challenge them for some reason, or do you not challenge them?
Just challenge him that I was told to cease and desist and stop producing when Mr. Burnoff told me.
Okay, I understand that. If that's the challenge, then I accept the evidence into the record. It's not a direct challenge, Ms. Kraft, that to the evidence that the state is offering. That's a different issue, and I understand what you're saying, and I'm not passing any judgment on what you're saying. I'm neutral here. That's my role, is to be neutral and give you a fair opportunity. Do you have any evidence? So the allegation, as I understand it, Ms. Kraft, is that the well has been inactive long enough that you're required to produce some documents that you have not produced. That's my understanding of the allegation. Mr. Hall, would you read the allegation from the NOV?
Yes. Yeah, let me pull it up there, Mr. Hearing Officer.
Okay,
Okay, again, one well, is operated by this operator. That well is inactive and has been continuously inactive and is uncontroverted, in its inactivity since April of 2024. The operator of wells drilled for oil and gas or service wells, this is from 1915, 25.8 MMAC, including seismic core exploration or injection wells, whether cased or uncased, shall plug the wells as subsection B of 1915 25A requires. Operator shall either plug and abandon a well or place the well in approved temporary abandonment in accordance with 1915 25 MMAC within 90 days after a 60-day period following suspension of drilling operations, a determination that a well is no longer usable for beneficial purposes, or a period of 1 year in which a well has been continuously inactive, which that is the operative provision here. And an operator is in compliance with subsection A of 1915 59 MMAC if the operator has no more than the following number of wells out of compliance with 1915 25.8 MMAC that are not subject to an agreed compliance or final order setting a schedule for bringing the wells into compliance with 1915 25.8 MMAC and imposing sanctions if the schedule is not met. 2 wells or 50% of the wells the operator operates, whichever is less, if the operator operates less than operates 100 wells or less. In this case, this operator has 1 well, 100% of which are inactive.
okay, so now in plain language, without
plain-
reading, yes.
Sure. It's been longer than 1 year in which a well has been continuously inactive. It is Craft's obligation to plug and abandon that well.
Okay. Is a plug and abandon, or I thought there was an or in the rule that said they could plug and abandon or do something else.
They're able to put it, if approved, temporary abandonment status.
If approved.
That is not even attempted to happen.
Okay. I just remembered an or in the rule, and that's why I asked you about it.
Absolutely
Okay.
correct. That's the or.
Okay. So Ms. Kraft, now that you've heard the
Yes,
plain
sir.
language, the plain language of what Kraft Operating is alleged to have not done, do you have any evidence that shows that you have done?
I have emails to the state land office and phone call records to the state land office. I have texts back and forth from the pumper that I had to, he had to let go because I was told not to get on location since when the well has been not producing since April of 2024.
So I understand that you have been told by the state land office certain things that have made plugging and abandoning not an option for you. I hear that. But it sounds to me like there was another option for you, that you could have petitioned the division to change the status of the well, and that wasn't done either. Is that right, Mr. Hall?
I'm not aware of any attempt to enter approved temporary abandonment status.
What I'm asking you, Mr. Hall, is did I say that correctly?
Could you restate the question? I apologize.
I said to Ms. Kraft, I said, I understand that you're not allowed to go back on state land. When was that effective, by the way, Ms. Kraft? When were you told you can't come back on state land?
It was back in around March of 2024.
Oh, okay. So, okay, I understand.
May I ask a question, Your Honor?
You can just let me finish this train of thought, and then by all means you can ask the questions. So when you receive that information from Mr. Biernoff at the state land office that you were not allowed to come back on the land, it sounds like you had another option under our rules, and that is to submit a petition to the division to declare that well to be inactive. Is that correct, Mr. Hall?
I don't know if I would say it that way. She had lots of options. Namely, she could have contested that finding by the state land office, but just coming in and complaining about the state land office, if that were allowed to happen, then wells could sit there unplugged indefinitely. Just because you claim you disagree with a finding, you have to take affirmative steps to contest that allegation if you disagree with it.
And that's why,
Yes.
you asked her about the court, about possible litigation.
Yes, sir.
Okay, but according to the rule you read a minute ago, did she not also have the option within a certain amount of time of the well going inactive to alert the division of that change in status?
She could have sought approved temporary abandonment status. She could have submitted C-115s, which it would remain inactive if there's no production. But I mean, she could have called the division and asked, but essentially we have no control over a lease. If the state land office says she can't get on there to produce it because a lease is expired, that's a dispute between them. Under
I
our rules and
understand.
regulations,
I understand.
is this
I
well
understand.
active or not? And
I
she's taken
understand.
no steps to contest that finding. And so I guess her claim is that we're supposed to help her fight the state land office.
I
And that,
understand, Mr. Hall. I got it. I got it. Thank you, Mr. Hall. So
Sure.
what is your question, Ms. Kraft?
Well, my question is, until I can get this sorted through with the state land office, can you put the well on TA, the status? Is that allowed? Can y'all do that? The state land
So-
office is telling me that operating the well without a valid lease in place is considered trespass, and I'm subject to my company to a civil action.
I understand. So, Ms. Kraft, I'd like to answer your question, but unfortunately, I'd be giving you legal advice if I answered your question. So I think,
Okay.
so may I suggest that you find an oil and gas attorney? There are some in Roswell. There are definitely oil and gas attorneys down in Lee County or in Eddy County that you could consult with for a path forward with the state land office. But from what I've heard so far, that I have no evidence to show that the allegation by the division is not true. Again, we operate under a preponderance of evidence standard here at the administrative hearing level. And Mr. Hall has submitted evidence that has been admitted into the record. And that evidence shows that, this one well is out of compliance. So with that, I'm going to say that Mr. Hall, you've supported your burden of persuasion that the allegation is true, that the civil penalty, what is the civil penalty?
$450, Mr.
Dollars. Okay. That the civil penalty is reasonable. And it sounds to me like the only thing left is a final order.
I would agree with that.
Okay. So Miss Kraft, since the division did prove its case on this one allegation, and the penalty is reasonable at $450, the division will issue an order signed by the director for you to comply with the order within 30 days, Mr. Hall, of
Correct.
receiving the order by email. Ms. Kraft, do we have a correct email for you?
Yes, Your Honor.
All right. Do you have any other questions?
What am I forgetting to ask you?
Well, you've asked me what you should do in this situation with the state land office, and I suggested that you consult with an oil and gas attorney, someone who specializes in this type of law.
So this $450 it'll be okay to be T&A'd until everything's cleared up with the state land office?
Oh,
No,
I'm
we-
not saying, hold on, Mr. Hall. Mr. Hall, I'm not saying that at all, Ms. Kraft.
Oh, okay. Okay.
I think the order will tell you what you need to do to satisfy this case. Now, if you don't want any further cases with this well, the oil and gas attorney that you consult can explain that to you, and also how to gain access to the state land or how to contest the state land office finding.
Okay.
Mr. Hall, anything further?
No, Mr. Hearing Officer.
All right. So Ms. Kraft, thank you for your participation, and I wish you the best.
Thank you, Your Honor.
You're welcome. All right, we're off the record in this case. Let's move on to case number 5 on our docket. This is 25940, Oil Conservation Division versus Colthurst MGT and INV.
Yes, well, as a OCD is present and ready. We have been in discussions with Coulthurst, I'll call them for brevity, has recently, I believe as of maybe yesterday, hired Mr. Suazo, who I've spoken with, and we have, I believe, you're aware, Mr. Hearing Officer, OCD has agreed to a request for a continuance, so Mr. Suazo has a chance to get up to speed as well as maybe do some negotiation with BLM.
Okay, thank you.
to that.
Thank you, Mr. Hall. I was just calling for entries of appearance at this point, and I do see Mr. Suazo. So good morning, Mr. Suazo.
Good morning, Mr. Hearing Examiner. Miguel Suazo for Colthurst. Sorry. I'm looking for-
MGT, yes.
Yeah, management and investments. Sorry.
Oh, management. Okay, very good.
Yes.
Thank you. So, Mr. Suazo, have you been provided a copy of the NOV?
Yes, I have. I've reviewed. The client is in the process of working with the BLM. Our federal lands group here at the law firm has a meeting scheduled with them for today. It's my understanding that Colthurst has found a potential buyer for these assets. And assuming that that is acceptable to the BLM, we are optimistic that we may be able to sort those issues out with the BLM, get an operator that's active in the area to acquire these assets and assume the liabilities. And then I can work with Mr. Hall and the division on the issues that they've identified in the NOV.
What are the issues identified in the NOV?
Well, I can't pull it up right now because I'm having the same issue that you and Mr. Hall were having. But as I recall from reviewing it last night, there's a number of wells that have not produced in some time. And, I think related to that are all the associated issues with reporting that the division typically wants to see. And so I know that the client, before retaining me to represent him, had been communicating with Mr. Hall about those issues, and he was granted some additional time to work that out with the BLM along their timeline. And I think in the past few weeks, it's gotten to the point where the prospects of them entering into a transaction related to these assets looks fairly promising.
Okay, thank you, Mr. Suazo. Mr. Hall?
Yes, to be specific, 3 wells, all 3 of which are inactive. So that's the number of wells at issue. I 100% agree with Mr. Suazo's representations from within reason and reasonable time period. OCD would prefer to see these wells become productive and or someone with assets and active in the area with the ability to plug and abandon them properly in the event. And so even though we've agreed to 1 continuance, I consider Mr. Suazo's request reasonable and in the best interests of the state of New Mexico.
Okay. How much, when do you want me to recall this case?
I believe we agreed to the June 25th docket. The other special docket, I think, is maybe May 5th. And I believe Mr. Suazo, to be comfortable, needed a little more time. There's some moving parts. I can certainly let him speak for himself, but that's the date we agreed to, June 25th.
And you said and what is the special docket date in May?
I take this with a grain of salt. I believe it's May 5th. So
May
it's
5th. Okay.
away.
All right. I understand, Mr. Swazo, you just got this case and you need to, work on it. But I'd like to hear what's going on with this case in a month. So I'm going to ask Mr. Hall to continue this case to May 5th as a status conference, not as a hearing by affidavit, but as a status conference so I can understand the progress the parties are making.
Understood. We will be prepared to give you an update at that time as soon as the date is set, and I'm assuming that is May 5th, so that should be fine.
Right. Thank you. So, Mr. Hall, does that work for you?
Sure. Just a logistical question. Do you like me to submit an order or just send out an email confirming that? Or what?
I think obviously we don't charge the division to continue cases. So I think a simple email to Mada-E or Freya asking them to continue this case to May 5th as a status conference is sufficient.
Certainly, I'll make sure Mr. Suazo is
Excellent.
copied on that.
I appreciate that. Thank you. Mr. Swazo, anything further?
No, Mr. Hearing Examiner, but thank you for your time and the division's time today.
Yeah. And did you receive a the exhibits in this case as well as the NOV?
I did. I assume
Okay.
you're referring to the affidavits from the division staff?
I am.
Okay,
I am.
yes, sure did.
I think there's more than just affidavits. I think there's also documents from or a database printout as well, showing whatever the status is that it's showing. But I just wanted to know if you received the proposed evidence in the case.
Yes, we do have those printouts
Okay.
of the well data and the affidavits.
Perfect. Okay, excellent. Mr. Hall, I already asked you if there's anything else. You said no. Mr. Swazo said no. So we're off the record in this case. Thank you.
Thank you.
Thank you.
All right, moving on to case number 6. This is 26032, the division versus respondent Cress Green Energy.
Yes, OCD present and ready to proceed, Mr. Hearing Officer.
And Mr. Hall, have you been in contact with anyone at Cress?
I have not.
Aha, okay. Did we send out the NOV and the docketing notice by certified mail?
Yes, and to the address, electronic and physical addresses designated by Cress to OCD.
And what was the response?
None. I'm trying.
I'm sorry, I
trying-
didn't mean it that way.
No,
What I meant was, what was the result of the mailing and the email?
I am having a hard time pulling up my documents that aren't already pulled up. I'm having internet issues. If I recall correctly, they bounced back.
Okay,
I'm not sure about the electronic, I'm pretty positive the physical mail bounced back.
okay. I'm gonna,
Actually, the email, I sent out the pre-hearing notice, I believe.
right,
And I don't think that came back, although I do apologize. The technical difficulties
right.
are making it hard for me to give unequivocal representations right now.
Okay.
I simply can't pull up my verifications of things at the moment.
Did, was there an agent or a responsible party that you were targeting?
Yes, Crest Green, I believe, is the name. I'm working off memory because I can't pull up the operator page either right now. But Crest, I think the name is Crest Green, and that's I understood it to be a green energy company, but Crest Green, I believe, is the designated contact.
All right. Okay, how do you want to proceed? Because I don't believe we have anyone here. I'll call again. Is there anyone representing Crest Green appearing virtually? I don't hear anyone. So, Mr. Hall, how do you want to proceed?
I would like to, and just for clarification as to why it might have been an issue to serve anyone, these wells have been continuously inactive. There's 6 wells, all 6 of which are inactive. They have been inactive since at least December of 2017. So nothing
Okay.
since.
Okay.
So based upon that, OCD would offer exhibits 1, 2, 3, and 4 attached to its pre-hearing statement.
Okay, they're admitted into evidence without exception. Are you going to produce a default order?
Yes, and just for purposes of verbally telling the court, we're seeking our typical plugging and abandoning civil penalty modification, all that, and the civil penalty in this case, given the 6 wells, 2,700. I will within the next 2 weeks present you with a proposed order.
Perfect. So the civil fine is 2,700.
Yes, sir.
All right. All right. Thank you, Mr. Hall. We're off the record in that case. Let's move on to number 7 on our docket. This is the division versus David Hinson, and this is case number 26034. Entries of appearance?
OCD present and ready.
All right. Have you been communicating with anyone at David Hinson?
Yes. It's somewhat convoluted. The designated contact, I believe her name is Diane Montero. Again, I may have that last name slightly wrong, but she sent me Mr. Henson apparently has passed away. She sent me an obituary. She has been responsive, however, understandably didn't really have authority to do anything other than she was listed as a contact. So we know the operator as designated in the system received these notices. However, it's my understanding that the owner and operator is deceased now.
Okay. All right. Is there anyone from David Hinson with us today? Not hearing anyone. How do you want to proceed, Mr. Hall?
This is we would like to offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
Okay, they are admitted into evidence without exception. How many wells are we dealing with here?
Only 1 well, which of course is inactive, and so along with our ability to plug and abandon, we would ask for a civil penalty of $450.
All right, and you'll produce a default order?
Yes, sir.
Okay, then with that, we are off the record. In that case, let's move on to number 8 on our docket. This is the division versus D, B, and G Gas and Oil. It is case 26035. Entry of appearance, please.
Michael Hall on behalf of OCD, present and ready.
Perfect. Have you been communicating with anyone at this organization?
Don't believe so.
No. And do you know whether the certified mail or electronic mail was returned?
I don't remember off memory, Mr. Hearing Officer. I apologize, and I cannot. Let me see
I
if
understand.
let me see if this one seems to be pulling up. So
Okay, great.
I can answer that. I don't know why this one is and other ones weren't, but let me let you know. On or about March 10th, 2026, the docketing notice and notice of violation were emailed. We believe they were delivered. They did not bounce back. They were also certified mailed on the same date, but those did come back to OCD returned on March 23rd. They were provided at the address provided by respondent to OCD.
Okay, I'll call again. Is there anyone from D, B, and G Gas and Oil present? I don't hear anyone. Mr. Hall, how do you want to proceed?
We would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
Okay, they're admitted without exception. And how many wells are we dealing with here?
We are dealing with 3 wells, all 3 of which are inactive and have been since at least January of 2012.
And what is the proposed civil penalty?
$1,350.
Thank you. Okay, and you'll draft the default order?
Yes, sir.
All right. We are off the record in that case. Let's move on to number 9 on the docket. This is case number 26036, the division versus respondent DC Energy. Entries?
OCD present and ready.
Thank you, Mr. Hall. Have you been communicating with anyone at this company?
I don't believe so.
Okay. Are you able to pull up this NOV?
I am. I'm able to let you know about our efforts to.
Go right ahead.
Yes. So March 6th, 2026, both electronic and certified mail were sent out with the docketing notice and NOV. They bounced back to us, the email, and as well as the physical copies also came back to OCD on or about March 26th. So
Right.
those were the designated contacts and addresses given to OCD by the operator and respondent. However, it looks like neither actually reached their destination.
I understand. How do you want to proceed?
We would seek a default order.
Okay. And do you have any exhibits?
Yes, sir. Offering exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
Thank you. Admitted without exception. How many wells?
It looks like 3 wells, all 3 of which are inactive.
And the penalty?
$1,350.
Well, that's consistent. Thank you.
Sir.
Okay. And you'll draft the default order?
Yes, sir.
Okay. We're down to our last case, Mr. Hall. This
Okay.
is case number 10 on our docket. It's case number 26038. This is the division versus respondent DSJ operations.
OCD is present and ready.
Is there anyone from DSJ with us? Mr. Hall, have you been communicating with anyone?
I don't believe so.
Can you pull up this NOV?
I think I can pull up the NOV. For some reason, this pre-hearing is not, the first page will pull up and the rest of it won't. I don't know what's going on there.
Okay.
But let me check on the NOV here.
All right.
I tried that first and it didn't work. Let me see. Okay, DSG. Okay, let me see if this works. Yes, I can pull up the NOV.
And will you tell me a little bit about your attempts to contact the respondent?
I can certainly tell you that that we sent electronic and certified mail as per our custom to the addresses designated by the operator. Given that I can't pull up, I'm going to try one more time, Mr. Hearing Officer, but I can't seem to get the pre-hearing statement to load, so I can't access Madei's affidavit. I can tell you, I don't know the dates. I can tell you that we rely upon the evidence in Exhibit 4 to our pre-hearing statement. I wish I could give you a recap right now, but I'm unable to view that at the moment.
Okay. All right. So how do you want to proceed?
We would offer exhibits 1, 2, 3, and 4 attached to OCD's pre-hearing statement.
They're admitted without exception. How many wells?
15, all 15 of which are inactive.
All right. And what is the proposed civil penalty?
$6,750.
Okay, Mr. Hall. And you'll prepare this default order?
Yes, sir.
All right, very good. Okay, then we're off the record in that case, and that concludes our docket for today. Mr. Hall, is there anything further?
No, thank you for your attention to these
All right,
matters.
Mr. Hall, thank you for your work, and we're off the record. Thank you.
Thank you.